Namaskar viewers. I welcome you to this new video in the series of course MJM025, course on Media Ethics and Laws, which is a part of your Mass Communication MA or PG Diploma, whichever you've chosen to do from the School of Journalism and New Media Studies at EGNOU. And if you have tuned in today as a journal layman, still this session would be immensely useful to you if you are interested in knowing what are the new things that we happen to add to our laws. As we have discussed in the earlier videos, we have a very flexible constitution. In our country, the constitution has a provision of amendments where, with the changing demands and roles of the society, the constitution can go on adding, deleting, altering certain acts and laws. Now, when it comes to media, there are certain new initiatives that keep on happening from time to time. If there is a law, there are new amendments, there are provisions that are made. If there is not a law pertaining to something, for example, digital media or information on the information law, such new laws keep on coming. So today, we shall discuss these initiatives. This is unit number 8, which is the last unit of your block 2 of the course MJM025. The unit, of course, is titled Initiatives in Media Laws. As always, let me take you through the unit structure, which is one of the learning instruments of how we make the units in EGNOU. So when you go through your self-learning material, which has been provided to you along with these videos, you would have a better understanding of the topic. So there you would know how your unit is structured. So in this unit, first we'll begin with the introduction, the learning outcomes, and when we come to the contents, we will discuss the initiatives on privacy, on intellectual property rights, the contempt of courts, right to information, and the codes for television, in which we shall talk about the program code, the advertising code, electronic media monitoring center, news broadcasting standards authority codes of ethics, and broadcasting content complaints council. Broadly, we'll touch upon these topics. Friends, as I always say, these are units of around 6,000 words, and this is a video of some 20-25 minutes. We can only introduce you to the concepts. But if this excites you, then we encourage you to go out there, read more, and research about the topics to have a better understanding. With this kind of a teacher advice, let me introduce you this unit. In this unit, you will see an overview of the issues related to intrusion in privacy, violation of IPR, and the contempt of court. We shall also highlight the key provisions of the Right to Information Act, the circumstances under which information can be withheld, the protections offered by this act, and we shall also go on to examine through case studies the application of some existing laws and question the implication of these laws. By the time you finish this unit, we expect you to kind of know something about each of these laws and the new initiatives in them. Let's begin with the concept of privacy. In the Indian law, the Constitution provides privacy from many grounds. As a layperson, as a person who is convicted for a crime, or even a person who is punished for a crime, you still have this right to privacy. That will entail the right against solitary confinement, the right against handcuffing, right against delayed execution, the right to shelter, the right against custodial death, and also against public hanging. And you would have the right of doctor's assistance even while you are in the prison, either undergoing a trial or serving a punishment. So such kind of rights to privacy are provided by our constitution. Now when we come to the rights of privacy of the people, where the press is concerned, as a journalist, what are the rights that you have to honor? Which are the rights to privacy either of your news sources or of the subjects against whom you are reporting? So for this, we will take you briefly through something that the Press Council of India talks of. So as per the Press Council of India, the concept of privacy has been discussed in their chapters. Now, following are the norms of journalistic conduct given by the Press Council of India on the right to privacy. So PCI says, things concerning a person's home, family, religion, health, sexuality, personal life, private affairs are actually covered by the concept of privacy, except when any of these matters become an issue of public interest. For instance, if my health is not permitting me to do certain duties or conduct my office as a public servant, then it can be reported by a journalist in the newspapers or on the news. But otherwise, it remains my private domain, and my right to privacy protects me against putting that out in the public. Another thing, a newspaper should not publish such matters of a person without his or her consent, whether truthful or otherwise, or whether laudatory or critical. Whether good or bad, you should always have the consent of the person about whom you are reporting on these matters. The family, religion, health, sexuality, personal choices, all these cannot be published without your consent. The press should not invade the privacy of a person if the subject matter is not of genuine public interest. The only defense that a press person, a reporter, a journalist can have of intruding into a privacy of a person, be it a public figure or a private person, is that it is in public interest. In no other chance would you intrude into the private lives of people. Now, this is broadly about, like we're talking in this section, in this unit, about the initiatives in media laws. So, laws say something, but the initiatives by a body like PCI, which is not governed by the law but which is respected by all the journalists, they give you such kind of guidelines. Let me come to the second point of this unit, which is about intellectual property rights and fair dealing. Friends, we have discussed in the prior units, the earlier units of this course, the concept of IPR. So we do know what it is, what is copyright. What are we discussing today is what are the initiatives when you talk of fair dealing. Now, IPR and bringing the information to the public domain, these are two coins, or I would say two facets of the same coin. How to balance them? For this, time and again, new initiatives keep on being enacted and executed. For example, something on IPR that got added is the first sale doctrine, which says the first sale doctrine means that once a work has been sold, the purchaser has the right thereafter to sell or distribute that particular copy. So you cannot claim copyrights or IPR rights again and again on the same work. I'll give you a basic example. IGNOU study material that you are studying has been written by intellectuals, academicians, and the industry professionals across the country and sometimes even globally. So they have written this material for your benefit and given it to IGNOU. Now, while they are submitting this work to IGNOU, they also submit a copyright form saying that this work is now IGNOU's copyrighted material. Now, IGNOU can use it in umpteen number of courses. For example, a course on media ethics and laws, you're studying here. We could even use it for our BA, we could use it for political science MA, for certain diplomas, because now the reuse, republication or the resale of this material does not anymore lie with the person who produced the chapter. This unit is now the copyrighted material of IGNOU, and the IPR thus cannot be claimed by the author. So once you have sold your material, you've taken an economic or a financial benefit for it, then the purchaser can resell, reproduce, or make available to the people as a repeated manner. Now, the reproduction of the content still is held by the IPR. When can a non-copyrighted material or a copyrighted material reproduced? Any work can be reproduced if the material is used for non-profit making activities of cultural value, such as education, art, science, or if the material is used in a newspaper or any other medium of mass communication for the sale or reporting of current affairs or in public interest. So even if it is a material protected by intellectual property rights or the copyright law, if it is being used for educational, cultural purposes and not for profit-making purposes, the use is excusable, but not without certain, things that are made on it. Certain laws still govern it. What is the length of the material that you can use? If I have to show a film, can I show a full film? Can I show the section of a film? Can I quote the full part of a book or just a section of the book? We'll come to that also. Now, in what more circumstances is the reproduction of the material permissible by the IPR law? If the material is used for commercial gain, however, it is not generally protected by the fair use rule. The nature and content of the material will determine the extent to which it can be fairly used. The quantity of the material used will determine whether its use can be deemed to be fair or not. Generally, up to 200 words of a text, but not more than 5% of the full text of a published work can be fairly used. So, when we talk of IPR, we also talk of fair dealing, the fair use of the material, the reuse of the material. So, these kind of provisions are there for that. Now, I've been speaking fair dealing, fair dealing. You would be curious to ask, okay, ma'am, what are the new initiatives on something known as fair dealing? So let me talk about it. Why do we speak about fair dealing? You need to balance this balancing act between respecting the intellectual property rights and fostering creativity and knowledge sharing with the importance of understanding and apply fair dealing principles in the digital landscape is very important. These days, you have now come to the digital space where this is the era of prosumers. You're a consumer as well as a producer. How much of your work is being used? Now, there is something that you need to balance about. So, how do you define fair deal? By definition, the legal doctrine that allows limited use of copyrighted material without permission under certain circumstances is known as the fair dealing doctrine. The purpose is to balance the rights of copyright holders with the public's interest in assessing and using creative works. Key aspects of fair dealing include research and study, criticism and review, parody and satire or news reporting. In detail, if I would say, the key aspects of fair dealing are using copyrighted material for academic and personal study, or quoting or excerpting for critique or review purposes, using the material in news stories, or using works in a transformative manner for humor or social commentary. For all this, if you have to use certain copyrighted material, maybe we have to think of ways where the copyright is maintained, intellectual property rights are not hurt, and the public also gains from these materials. So there's a difference between fair dealing and fair use. There are jurisdictional differences. Fair dealing is the word commonly used in UK, Canada, Australia, whereas the term fair use is used in the US. Specifying, if we have to specifically say, then fair dealing is more perspective oriented with specific purposes, while fair use is a broader and more flexible kind of a doctrine, term, or methodology, whatever you would want to call it. Fair dealing holds all the more importance in the digital age. The challenges in the internet age are rapid sharing, remixing, and repurposing of the content online. Like we spoke in one of the earlier lectures, the concept of content curators. Content available on different websites is curated under one domain so that you don't have to visit different websites. So this is the challenge in the digital age. If my content in the name of curation is being reproduced again and again, what authority, what gain, or what creative satisfaction do I gain from using or maintaining that content? But the opportunity in the digital age is educational and creative uses are facilitated by the digital tools and also the platforms. Therefore, fair dealing becomes all the more important when we talk of the internet age. Now, in the internet age, the criteria for fair dealing are, you can actually divide this criteria in terms of purpose, nature, amount, or the market impact. If there is a non-commercial, educational, or journalistic purpose, you can consider the content can be used under the doctrine of fair deal. The type of work, for example, if it's a factual work or it is a creative work, small versions versus entire work. I'm just using a very small section of a book, or I'm using the entire book in the name of fair dealing. So on all this would depend the criteria. If there is no significant impact on the market value of the original work by the usage in the name of fair deal. If I am reproducing the book, for example, you write a book and I take a photocopy and give it to all my students. So rather than buying your book for which you would be getting a royalty or a name, they would all be using the photocopy. So is this called the fair dealing? Friends, these are larger questions, and as always, I would ask you to ponder over them. Research, find out, discuss, think, and come at your own conclusions, because laws cannot cover anything. Therefore, we come up with ethics, regulations, and even the new initiatives like we are talking about today. I would take some examples, using a short clip of a movie for a classroom presentation. Can you call it a fair dealing, non-protected IPR thing? Or would you say, no, this would be an IPR issue or you cannot use it? Or quoting an excerpt from a book for a critical review? So these are points for you to think over. Now, there are ethical considerations when you are using a copyrighted or IPR protected material. Considerations like respect for the original creators, proper attribution and credit, and avoiding misuse that harms the original work or its creator. As long as you are ethically thinking of these things, probably the IPR and fair dealing would go hand in hand and would go smoothly. But respect to these ethical considerations is a must. Now, we've spoken of IPR, fair dealing. Now, let's come to the next section of this unit, which is Contempt of Courts. Now, the initial act that was enacted in 1971 said that if there is a contempt of court, then there would be punishments. A contemptor can be punished with simple imprisonment for a term extended up to 6 months, or fine of 2,000 rupees, or both. Now, this was 1971. We wanted new initiatives to actually look at this act in the new light of the changing societal norms. So there was an amendment made to the Contempt of Court Act of 1971. Amendment in 2006 said that it provides truth as a valid defense in the contempt proceedings. If the court says, okay, Padmini has undergone this contempt of court and she needs to be punished. But if Padmini has a proof that this was only the truth, what I reported was true and it was not my own opinion, then she can be excused. And this may not be considered the contempt of court. So this kind of privilege was given by this amendment of 2006. Now, this is the act, the amendment, the new initiative. Let me define the act to you. Why do we need this Contempt of Court Act? To define and limit the powers of certain courts in punishing the contempts of court, to ensure the respect and authority of the judiciary. Whatever is being reported in the judiciary, this is the highest thing in the democracy. We consider judiciary as the supreme power. So it needs to be respected. It needs to be protected. Therefore, this act was enacted. Now, there are certain types of contempt. Just pay attention to this kind of a thing. There are civil contempts and criminal contempts. By definition, a willful disobedience to any judgment, decree, direction, order, writ, or other processes of court, or a willful breach of any undertaking given to a court is considered as a civil contempt of court. However, what is a criminal contempt of court? Any publication, whether by words, spoken, written, or by signs, or any visible representation or otherwise, or any act which scandalizes or tends to scandalize or lowers the authority of a court, or any act that prejudices or interferes with the due course of any judicial proceedings, or the acts that interfere or obstructs the administration of justice in any manner is considered to be the criminal contempt of court. So if you're interfering with the procedures of the court or the judicial acts, it is a criminal contempt. And if you are willfully giving wrong information to the court or disobeying the court, it is considered to be the civil contempt of court. What are the defenses available? When can you say, oh, I did not mean to contempt the court? Only if truth, fair criticism, and innocent publication or distribution was being done. Only then can you have a defense against the contempts, which means it is justified by truth if it is in public interest, by fair and reasonable criticism of judicial acts in public interest, or any publication or distribution of matter not knowing to be contemptuous. I was not aware that by publishing this I am doing a contempt to the court, or it was in public interest. Only then and only then can you put a defense against this act. So as journalists, you would also be interested in knowing what are the penalties if I'm punished. The punishment is simple imprisonment for a term which may extend to 6 months, or a fine which may extend to 2,000 rupees, or both. So with all the amendments and implications, this remains the same since 2006. Key sections in the Contempt of Court Act that as journalists, as future reporters, you should actually be aware of is Section 2 that deals with the definitions, Section 13 that talks about contempts not punishable in certain cases, Section 10 which talks of power of High Court to punish the contempt of subordinate courts, and Section 12 which deals with punishments for contempt of court. So Section 2, 10, 12 and 13 are something that you cannot not know as a journalist. Let's come to something which is a problem in reporting sub judice matters. Now you would ask me, okay ma'am, if I'm reporting a matter which is under the court proceedings, I am supposed to tell about it. How would I say that am I meaning a contempt of court or not? Now this is a very tricky area, of course. Problems in reporting sub judice matters are prejudicing the trial, potential to influence the outcome by swaying public opinion and the jurors. Therefore, the constant practice of parallel media trial is criticized and discouraged. So there would be a court case about a very celebrated person or a bigger issue, and if you sway the public opinion by putting news items or reporting about it, then the contempt would be actually done. So you have to be very careful in reporting the sub judice matters. Risk of being charged with contempt of interfering with the judicial proceedings and violation of fair trial rights, undermining the accused's rights for a fair and impartial trial. Sometimes media tends to overuse its power. It declares somebody as the criminal even when the court is still doing its research, or the court's proceedings are still on. So these are the risks and the problems that you should steer clear of while reporting the sub judice matters. Other things are misinformation and sensitizations, spreading unverified biased information regarding the public or giving misinformation to the public, ethical concerns like compromising journalistic ethics by prioritizing sensationalism over accuracy and fairness. Courts may issue gag orders or impose reporting restrictions to ensure fair trial proceedings. So judicial warnings and bans should actually be honored. And the legal consequences, potential legal actions can be taken against media organizations and journalists for improper reporting of sub judice matters. Therefore, you should be very careful. Another related issue to this is scandalization of court. What do you mean by scandalization of court? Any act or publication that disrespects or discredits the judiciary, undermining public confidence in the judicial system is considered to be the scandalization of court. The forms of scandalization can be publications, speeches or conduct. That means any articles, social media posts, comments that defame the judges or the judiciary, public statements or speeches that attack the integrity of the judges, or actions or behaviors that show contempt of the court or its proceedings are thought to be scandalization of the court. The legal context to this is scandalization is a form of contempt of court punishable under various laws such as Contempt of Court Act 1971, and the purpose of this is to protect the authority and dignity of the judiciary and maintain public trust in the legal system. Examples can be if you are publishing false allegations about a judge's moral conduct or impartiality, or if you make derogatory remarks about the judicial process during a public speech. All these things are covered under scandalization of court and are punishable under the Contempt of Court Act. The consequences can be legal penalties, fines or imprisonment, and even the reputation damage, harm to the individual's damage or the credibility if you are covered under this act. Let me come to the next thing, which is the last section of this unit, which is the right to information. Now, we in India have a Right to Information Act, which is based on the premise that democracy must involve an informed citizenry and that a government must be accountable to those that it is governing. Based on this premise, we came up with a new act. Now, this was a new initiative. This was not an initial act in our constitution. This was a new act that came in, the Right to Information Act. By definition, the right of the citizens to access information from public authorities to promote transparency and accountability is their right to information. As per the legal framework, This act is governed by the Right to Information Act 2005, which was enacted in India. So your right is governed by this act, and it ensures the public's right to know about the government functionings and decision making. So the right in India is no more only the right, it is lawfully protected under this Act of 2005. The key provisions of this act are: it is the duty to disclose information proactively by the public authorities. The RTI application is one key provision of this act, which says that citizens can request information in writing or even electronically. The response time is limited. Information must be provided within 30 days of the citizens seeking the information. And there are certain exemptions to the RTI Act, which says that certain information is exempted from disclosure. For example, information that would hinder the national security or person's privacy. So under these provisions, the authorities can deny or they are exempted to provide the information on the RTI Act. Benefits of the RTI Act, of course, are transparency, accountability, empowerment. How? This act promotes open government and reduces corruption. It holds public officials accountable for their actions and empowers the citizen to participate in the governance and decision making. There are certain challenges, of course: no laws, no acts, no ethics. No constitutional remedies or amendments come without challenges. So does the RTI Act. There are challenges in implementation, issues of awareness, and even misuse. There are delays and non-compliance by public authorities. Even if you've made a law, an act, authorities do tend to hide information or delay the giving of the information. Limited public awareness about the RTI processes. Not everybody in the country is aware that they can seek information under the RTI Act. And there are instances of frivolous or even vicious RTI applications. There are RTI activists, there are people who keep on putting applications and burdening the government departments with frivolous information being asked. So these are some of the challenges, but nevertheless, this act is going on in a very, very nice manner in this country. It also undergoes amendments, and the citizens now have this power of asking the government officials of certain information that they need. Now, after these laws, let us come to the News Broadcasters Association and the ethical concerns. So we've discussed these laws and the initiatives. Now, one of the ethical initiatives that was made and that you should be aware of is the initiative of news broadcasters. There was the Code of Television that was given by the Cable Television Networks Rules of 1994. This code provides two variations. One is the program code, another is the advertising code. The program code, just to give you the glimpses of the program code, it prohibits certain things like offenses against good taste or decency. If there is a program which is offensive, which is against the good taste of decency, or which contains criticism of any friendly country, which contains attack on religion or communities through its visuals or through its words, or a program that contains anything obscene, defamatory, deliberate, false, suggestive, intrusion, or half-truths, or any program that is likely to encourage or incite violence, or concerns anything against maintenance of law or order, or something that promotes anti-national attitudes. Any such thing in a program is prohibited by the program code of the Cable TV Network Act of 1994. Other things that a program is discouraged from showing are things that contain anything amounting to contempt of court, containing things against the integrity of the president of the nation or the judiciary, or anything that affects the integrity of the nation, something that encourages suspicion or blind belief. All such things cannot be shown in a program. Now, this also gave you a second code, which was the advertising code. This code controls the content that can have any things that degrades a race, caste, color, nationality or creed, something which is against any provisions of the Constitution of India that tends to incite people for crime, cause any violence or disorder, breach any laws, or glorifies violence in any manner. Such kind of advertisements cannot be shown on the TV or the cable TV. Something that presents criminality as desirable, or something that exploits social evils or glorifies evils like dowry or child marriage, things that promote directly or indirectly production or sale of things like cigarette, tobacco, wine, alcohol, liquor, or any other kind of cannabis products. So these things are discouraged through advertising. So these codes tell us that you have to be ethically responsible for the content that either goes in your advertisements or your programs through the television. To monitor this, the government came up with Electronic Media Monitoring Center. Now, what is the EMMC? Electronic Media Monitoring Center of the Ministry of Information and Broadcasting, Government of India, is a premier setup which has advanced technology which is meant to monitor, record, and analyze the broadcast content. It is entrusted with the task of monitoring the content which is being aired by the satellite TV channels for any violation of programs or advertising codes under the Cable TV Network Act. So this act, are there violations? This is being monitored by the EMMC. EMMC has a technical facility to acquire, store, and even retrieve the content of over 900 channels which are beaming over the Indian territory, so that violations of the code can be framed and these can be checked. So whenever EMMC says that such content is being given, either it is censored, the authorities are told to give cuts to this content, or you issue warnings. For example, tobacco smoking is injurious to health, or this program does not glorify drinking alcohol or using drugs. So either warnings, censorship, cuts, whatever is befittingly felt is given by such things. There is another important organization that looks after the broadcasting ethics, which is the News Broadcasting Standard Authority, which has a different codes of ethics. So it has codes about television news channels. It says they should recognize that they have a special responsibility of adhering to higher standards of journalism, and they have the most potent influence on public opinion. This code highlights the importance of maintaining impartiality and objectivity in reporting and ensuring neutrality, and it also says that television news channels should ensure that they do not show any kind of male or female nudity. News Broadcasting Standards Authority also says in its codes of ethics that channels must not intrude on the private lives or personal affairs of individuals unless it is clearly established that this is a larger and identifiable public interest. This code of ethics further goes on to add that news channels will not broadcast any material that glorifies superstition or that has any kind of non-scientific temperament in any manner, or as a guiding principle, any sting or undercover operations should be discouraged and they should only be used as a last resort by the broadcaster. There is Broadcasting Contempt Complaints Council. If all these codes are not followed, what happens? For non-news television channels, Broadcasting Content Complaints Council, which is BCCC. BCCC was set up by the Indian Broadcasting Federation. It implements IBF, which is Indian Broadcasting Federation's self-regulatory contents guideline, and has the power to impose fines or actually book the erring television channels. With this, friends, I kind of come to the end of the contents discussed in Unit 8 of your MGM 025. So to sum up, in this unit, we have considered the privacy, contempt of court, the right to information, codes of ethics which have been recently implemented by the NBA. We have also explored the role of Electronic Media Monitoring Center, which monitors, records, and analyzes the broadcasting content. So this unit actually considers the initiatives which are related to ethics and laws in the Indian context. So friends, we have been discussing the laws in the previous units and also the ethical concerns. And in this Unit 8, to wind up Block 2 of your course on media ethics and laws, we spoke about the initiatives, the new comings in the ethics and even in the laws of this country. So as the future generation of journalists, we give to you this responsibility of reading, knowing, understanding your social context, and maybe coming up with new initiatives as and when they are required for the betterment of the society. With this, I say goodbye to you, but not without the teacher advice of please go through your SLM, which is a self-learning material. Listen to the videos, listen to the podcasts, and come and attend the conferencings, the counseling sessions that are held face-to-face on Saturday, Sunday, which are held through television, through radio, and even online for the best benefits and for enjoying this course to the maximum. With this, wishing you all the luck in your learning journey. Thank you.